Thank you, Marlon. Thank you, Suzanne, for being on today to help us monitor the chat and drop links. I'm Kelly Stoner. I work with the Tribal Law and Policy Institute. I think I've been there for about 14 years. And I am so happy to have my colleague and friend co-presenting with me today, Shelley Miller. I just wanted to let you all know, Shelley and I were talking before we got started, and we have been working together for over 25 years. So she is going to have a dual role here today. She's going to be bringing that advocate perspective. And I think you all know that most of us who've been in this domestic violence field for years believe that it is a best practice for attorneys and advocates to be working together on these cases. That doesn't mean it's not without challenges, but it brings that safety service providing perspective that the lawyer might not have. And also towards the end here, Shelley and I are going to monitor our time. We do like to visit. We like to visit with each other. We like to visit with you all. Uh, we're going to delve into the Circle Project a little bit more. Again, Native Alliance Against Violence, that's Oklahoma's tribal coalition. Shelley's the executive director. Shelley, I think I'm introducing you. Sorry. I'll turn it over to you for a second. But that is a project that pairs attorneys and advocates together during the entire case until it is done. So with that, Shelley, I'm going to turn it over to you to introduce yourselves, and we'll be off and running.
Good morning, everybody. It is so wonderful to be here today, and of course, being able to provide a little bit information with Kelly Stoner. As she said, we have been working many, many years together, and it is just so wonderful to come together today and talk about some of the issues that we have come across during the Circle Project and some of the successes that we've had as well. So thank you for inviting me, you guys, and I'm just glad to be here.
Great. So today's presentation is going to focus on protecting client information. That is key to client safety. And so we're going to move through some of these concepts, and you may or may not have questions. You can ask us anything at this point in our careers. I don't know if it'll be something we haven't heard or dealt with before. And I just want to give a shout out to April. Stay warm. She says it's 50 below in Bethel,
Oh,
Alaska today. It reminds me of Grand Forks, North Dakota. Okay, Shelley, you're going to have this first slide. The disclaimer was earlier. That'll be included in the deck.
okay, sure. So I don't know if we wanted to go over the objectives of the presentation, but our knowledge check says, why is it important client information is protected? What are we doing? Why are we talking? Why is this such a discussion for us today? And so we would like to invite you guys to put in the chat, why is protecting client information so important? And we just want to say we are hoping to get lots of interaction from you guys today. This won't be our first knowledge check, but we would love to hear some of your ideas.
And I see safety. I see trust building. Attorneys have an ethical duty. Thank you for bringing that up. It's the law, integrity. There are abusers everywhere. Integrity of the process. Okay, that's great. Let's go to the next slide where we listed a few. Safety, 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 always.
Especially with advocates, that safety piece is the most important. So whenever we're thinking about protecting client information, we are always thinking about providing that safety for her, making sure that her information is kept protected, and that also helps protect her in her journey as well. Providing privacy that's necessary for clients to be able to speak freely is extremely important. If she can't feel comfortable telling us what she needs, then she's not going to give us the information not only that attorneys need, but also that advocates need in order to develop those safety plans and provide those resources for her. It's also a place that information is controlled by the client so that they have client autonomy. They have the ability to say, this is my journey, this is where I want to go, and we are the people who help provide those resources to get her there where she needs to be.
Next slide.
The basic rule for any advocacy program is that we don't share outside information with other programs unless the client gives us that permission, written permission in writing to do so, or if it's court mandated by a judge.
Next slide, please. Okay, so today we're going to go over three concepts. Now, everybody keep this in mind. I'm the attorney. I'm seeing through the attorney lens. Shelley's the advocate. She's seeing through the advocate lens. And as we move through this and talk about these concepts, you might see that we have very different perspectives on these topics. So the three we're going to be discussing is privacy. The next one is confidentiality. And the next one is privilege. It is protected by a statute, the client information. So let's go to the next slide. Privacy. It is the expectation that when a client shares information with another, doesn't have to be a professional, that information will be held tightly unless the client authorizes or approves of some sort of disclosure. This can be two friends and the information is being shared and the client's expecting that to be held tightly. I do want to say one word here, though, as we move through this. There are different types of advocates, and they all have different perspectives or mandates on the information using this client information. And so some clients, like the grassroots type that Shelley is, they are usually governed by a tribal code or just their organizational conditions or restrictions or policies. Or you could be grant funded that also is going to have some perspective on privacy and confidentiality. So privacy is probably the least protected of all. There's not necessarily a sanction if it's violated other than the trust, as Shelley was mentioning, of the victim. So let's move down to the next slide. Now let's bump it up a little more protection here. Confidentiality is an ethical duty to keep the client's information private. And ethical duties, lawyers are going to have them, healthcare providers are going to have them, therapists are going to have them. And this is important. As you see, as we move through these concepts, there's going to be more and more protection for the client information and sanctions if that is violated. In other words, the client didn't give permission for that information to be shared. Client statements are meant only for the service provider. Again, can only be disclosed with client written consent. We're going to have a slide on that later. And if the service provider, and lawyers are going to be a mix here because we are going to have confidentiality and we're also going to have privilege. So we're going to talk about that in a minute. If this confidentiality is breached and the service provider discloses client information without client permission or a court order, they can be liable for an ethical breach of duty. They may be sanctioned. They may lose their license. So you see that we're building on this. So that's confidentiality. And let's go to the next slide. The types of information that are usually, because we have to talk generally here, protected by this ethical duty of the service provider to keep the client information confidential, can't disclose it. unless there's a written permission or a court order. Usually there can be so much more to this. This is a general list. The name and address of the client requesting services, the name and address of the client receiving services, other private identifying information like their telephone number, their birth date, their health issues, therapy they're getting, treatments they're getting, the location of the client, which is huge, domestic violence shelter locations, and any information in any form. These are just the general pieces, any information that client has shared. Next slide. Now, I'm going to keep going unless I see a question. So we've talked about privilege, not a lot of protection. We've talked about confidentiality, more protection, possibly sanctions. Now we're going to talk about privilege. This is usually found in a statute. It's an evidentiary rule that prevents, so the law prevents disclosure of information, even if it's relevant in court. Particularly, this privilege will come into play when the information was originally communicated in a professional or confidential relationship and it's covered by a statute. Lawyers are probably thinking attorney-client privilege. We can't disclose without client permission or court order information that client has. There's a few more exceptions, but for today, we'll go with those. Information that the client has given us, and it's protected by a statute. Next slide. Privileges protect client information, like I said, by statute or case law. And guess what? There are sanctions if the professional violates this, and possibly even criminal consequences. So you see how we're building on this. So I do want you all to know, and you see this in the note down there, when you're practicing in tribal court, because states will have their own privilege. When you're practicing in tribal court, it's a good idea to take a look at any statutes the tribe has on privilege, attorney-client privilege or advocate-client privilege. I review a lot of codes. I've seen some tribal codes that give an absolute privilege, where in the statute it says the records can never be disclosed under any circumstance. And then there are other tribal codes that will say only upon court order, first reviewed by the judge before it is presented outside in the courtroom. So I just want you to be sure to know the difference between these concepts and which ones are the strongest. I would strongly urge you, if you don't already have this in the tribal code and you have any ability to make suggestions, that you get a privilege statute at a minimum between the advocate and the client to protect those records. Next slide. Okay, let me check to see, do we have any questions on any of those? Because we might as we keep going. All right. Who is the holder of the privilege, the statutory protection that covers, encapsulates the client information? This may come as a shock to some of you in the legal field, because we are taught in law school, winning the case is super important. That's how we get our clients. That's how we get our professional relationship. And sometimes I wasn't taught in law school about domestic violence, the needs of victims, the safety issues that are present in those sorts of cases. And especially when I was young in my practice, I think I transposed what I thought was best for the client into my argument. I was sort of advancing it because I thought it was best for the client. And I thought the client deserved the washer and the dryer. And I thought the client deserved all these other things. When the client is giving information to us, we need to remember what Shelley's already pointed out, and we're going to point it out several times during the presentation. The client steers the ship. The client is the holder of the privilege. It's her information. And so if the client wants to waive the privilege, and in domestic violence cases, sometimes they want to bring someone into the interview room with the lawyer. Um, Best practice for the lawyers out there is to have an agreement that if a third, you just have it handy. If the third party's present in the interview room, unless it's medically necessary because of some sort of disability, that there's an argument that the attorney-client privilege has been waived. I think that's critical. But if the client insists, after full disclosure from the lawyer, and says, I want to take this risk, I understand, but I need my advocate in there. I need my grandmother in there. I need my auntie in there because they're a lot of times going through trauma. And so we need to always remember the holder of the privilege is the client, not the attorney, the client. But the attorney, for obvious reasons, needs to have an agreement that that has been explained in full. The client voluntarily consents and has no question and still desires to have that third party in the interview room. Next slide. Okay,
I
Shelley.
want to talk about I want to talk a little bit about confidentiality, just kind of back up a little, because for confidentiality for advocates, it's a little bit different because we're thinking about safety. We're thinking about if I divulge this information, I could get somebody in a situation where they're abused, where they're killed, where their partners or their kids or their animals are killed. So it becomes we're thinking about confidentiality and keeping that at a point to where we're protecting her information and her story so that we are keeping her safety at the forefront of everything that we're thinking about and doing. Because that and foremost is our cornerstone. It's important for advocates to keep that confidential information so that we're not divulging anything that could get her in a position where it could harm her. When we're talking about data that we're collecting and everything, sometimes especially when we're coming from small communities, we have information that we don't necessarily consider maybe that would divulge somebody's name or who that person is. But when we're in small communities, sometimes it's a matter of saying somebody, maybe we're doing case review or something and we're talking to another professional and somebody else is in the room and we're talking about somebody who's from an off tribe not around in our community, and there's only one family who is who that could be. We have ultimately divulged who that would be. And so it's important to think about the data and the information from a person, not as just their name or their address, their social security number, but also that identifying information that we might not always think about in everyday conversations that could divulge who that is in our own small communities. Being an advocate in a small community, everybody, once you get established, everybody knows who you are, what you do, what type of advocacy you're working with. And so whenever you have somebody coming in for services or even talking to you out in the community, they're like, oh, did you see her talking to Shelley? Because Shelley is a domestic violence advocate. She's a sexual assault advocate. And so just being out in the community sometimes can put her at risk. And just being mindful of where your office is, and when we're talking about confidentiality, because people coming in to see you, there was a time when we were placed directly in the administrative offices in our tribal program was right in the middle as soon as you walked in. And so everybody knew when anybody came in to talk to us for services or just came into our office, and that became a point of gossip. And so in order to make sure that we were keeping her private, we had to move our offices off site so that it wasn't so out in the open as to who was coming directly into our office and who was coming in, and they weren't having to sign the tribal intake sheets or sign in the sign in sheets or being led to our office and stuff like that. So there are a lot of things to think about when we're talking about confidentiality, especially when we're advocates, just making sure that we are being mindful of every piece that comes along with that, because we're talking about her, making sure that her and her family are staying safe through the entire process. Um, I also wanted to talk about whenever we have that release of information, sometimes not only domestic violence programs, but other programs give you that sheet up front and say, here, sign this. It's a release of information in case we need it. But that's not really best practice. And we want to make sure that if we're going to have a release of information, that it's always listing that specific information that we're going to disclose, that it's not just a general blank form, that it identifies who we're going to give this information to, that the client has the ability to sign it, that it includes an expiration date, and that client understands that if she decides, she goes home and says, never mind, I don't want to do this, she can come back to the office and take that back and rescind her permission to utilize that release of information. Our grant special conditions sometimes say that we must follow certain rules and stuff around confidentiality. So I want to make sure that we are always paying that special attention to those grants. And always, whenever we're talking about having a client sign a release of information, that we do it with informed consent, which means that we're always telling our clients who's going to get that information, what that information is going to be, what type is going to be released, how that information will be used, and is that recipient of that information going to be a public record agency? Because that makes a big difference on how that information is used and what information may come out in court or may be accessed by the public after it is done and over with. So just always making sure that she's informed of every piece of that is so important whenever you're an advocate. And making sure that she is keeping safety at the forefront of everything she's thinking about.
I want to, Shelley, add a little bit to confidentiality there. Thank you. I want to make sure everyone knows that different advocates have different duties to confidentiality. And Suzanne, if you wanted to put that 8-minute video link in the chat now, this is a video that Shelley Miller and Bonnie Claremont, who you've heard from frequently, sat down and talked about this. But in a nutshell, I would want you, especially everybody out there, is grassroots advocates like Shelley will keep the information confidential unless it's torn out of them. But advocates who work for a prosecutor or in a law enforcement office have a duty to their agency to disclose information. They're gathering information. And even healthcare providers sometimes have a duty to disclose certain information. So the grassroots advocate is, to me, the advocate who is totally victim-centered, and they're not sharing without a release of information. And the release of information, Shelley kind of went through that, but to me, it's like once the toothpaste is out of the tube, you can't put it back in. So once this information, the client needs to understand that once this information gets out there, the person it's disclosed to may not have a duty to keep it confidential. And there are other ways. Shelley talked about inadvertent confidential violations. I think one that was so clear to me as I was on the bench, I'm sitting in a restaurant and there were big high seats behind us, but the couple in front of me, who were both professionals, who thought they had some privacy because of the big barriers between the seats, talked about a fact pattern that I recognized. And it was a small tribal community, like Shelley said. So we always have to be vigilant. You may not mean to disclose it, but it's disclosed nonetheless. And there are other ways. We're going to talk about waiver of the privilege and things like that, but just keeping that in mind, because like Shelley said, when you think about client information, it is directly tied to victim safety. Anything to add on that, Shelley? And then
No, I just think safety is so important for us to think about whenever we're talking about confidentiality. I mean, there are times when we share information or even our victims want us to share information with other agencies in hopes that it will help with her case. But being mindful of how that information will be used or how it will be out there is so important for her. I remember a time whenever there was many years ago where there was this young lady who came in and needed information to be shared. But also, and it wasn't, I was not the advocate, it was somebody else in our community, but they had shared information without the client's knowledge, thinking that it was going to be helpful. And sometimes, I mean, we all, as advocates, that's what we want to do. We want to be helpful. We want to keep safety at the forefront. But this advocate had divulged that there had been in the course of her marriage an actual she had an abortion and didn't tell anybody, not even the perpetrator of the relationship, and that came out in court. And it was so devastating to not only her but everybody in that community because that was not something that was an option in their community. And so for her, life was over. And after that court session, she actually took her life. And that is so important to keep whenever we're thinking about advocacy, being mindful of things that we are privileged to, things that we are told. And if you're a good advocate, you are told quite a few things that you use in order to be like keep her safe, to keep her information confidential, to make sure that she gets all of the resources and things that are available to her. You want her to share those stories so that you can help her in the best way possible, but also being mindful that she's sharing information with you that is very private and very can be harmful if it's ever leaked out in any capacity. And so advocacy for me and keeping that things confidential is so important because you only get one chance. And for the young lady who took her life because of things that were came out in court, that was devastating. And not only to her, I mean, think about everybody else who loved her. And so it confidentiality means something way more than just keeping somebody's story to a minimum.
and we have to always, as the comments are pointing out for attorneys, always aware of inadvertent breaches of confidentiality or a privilege. It's the comment seeing lawyers reading client documents in coffee shops. You know what was big for me was we're in court, female lawyer, female client. She needs to go to the restroom. And I'm in there looking underneath the stalls to make sure there aren't any feet in there because I don't want her talking about the case in the restroom on the court grounds. Just you have to be mindful and vigilant about this at all times. At all times. Coffee shops, I once was privy to a case where the attorney had left the client file with the client's name on the front seat of their car while they ran into the tribal complex to get something. And people were walking by looking, saying, oh, is she filing for divorce? Oh, is she inadvertent? But we always, always have to be mindful. Okay, there is a question. Um, how do you prepare the clients if information comes out through other sources? The advocate may be keeping it private, but in court, the information still comes out through other sources. I think this is a preparation thing. I can remember telling my clients, Shelley and I were actually working on to get together on cases. She would say he's a meth addict and he got me involved in it, but I don't want to talk about it. And I can tell her the first thing out of his mouth is she's a meth addict.
Mhm.
And so we talked through all that, and she was very amenable to being proactive, to getting an evaluation. She wanted to get into some treatment. So we were able to really flip that around to a positive, because the very first thing out of his mouth was, she's a meth addict. And she just looked at me and she said, "You were right." I think she thought I was some sort of psychic or something. But power and control drive these cases, and they're going to do whatever they can to try and disempower that client when they start to get a little bit of power through legal representation. So I would just say, prepare, prepare, prepare. And this is what we're going to do if this happens. And this is what we're going to do if that happens. But we're going to go through a few slides here. If we can go to the next one, we're going to go through a few slides about um, inadvertently waiving the privilege. And the client can do that too. Not only the attorney, but the client can do it. Here's a list of generally recognized professionals who have a statutory duty to protect client information. And notice at the bottom, we say domestic violent advocate, but again, not a client witness, a victim advocate that's working in a prosecutor or law enforcement office. And I'm going to hope the grassroots advocates are going to be explaining this, because the victim can go into the prosecutor's office, they're prosecuting a crime, she's the victim. That grassroots advocate is the person that's going to say, just know whatever you say in there, it's not confidential, and it's probably going to be disclosed to the prosecutor. So that was the whole point of bringing up the different types of advocates and giving you that 8-minute video where Shelley and Bonnie go through it extensively. Next slide. Shelley, jump in now if you need to say something. Let's talk about waiving the privilege. This goes out to the lawyers or the advocates who have a tribal statute that protects their records. There are a couple of ways to waive it. We've talked about some of them. Third party in the interview room, that's a big one. The client knowingly and voluntarily signs that release of information. But here are some things the client might be doing, and so lawyers and advocates might want to mention these things to the clients. If you put information that's confidential, same thing you told your lawyer, same thing you told your advocate, on social media, guess what? It's waived. It's out in the public. It's no longer protected by a statute. I think third party, well, that's a big one, because texting it on group text, all those things can compromise that privilege protection. The third party in the interview room, especially in Indian country, when younger clients are coming in, they need their grandma, their aunt. Remember, the client holds it. If they want you to do it and they want to say, "Yes, I understand everything, you got that in writing, it's signed," then you can, that it's still compromised. Whether or not somebody's going to figure that out and call you to task for it, I don't know. But the client is directing the ship here. And then putting the statement at issue, such as bringing it up in trial. That also is called opening the door, and opposing counsel is going to ask a lot of questions, and the client can't say that's confidential information, or there's no objection, privilege information, because the client has already made the statement. So preparation for trial is very, very important in domestic violence cases. Yep. I see also in the chat, Suzanne is saying, "I used to tell my clients that I pretend I don't know them in public. It's not because they don't like them, it's because you don't want to compromise anything." And Shelley mentioned that earlier as well. In the grocery store, if Shelley were to do this in her small town and run up and start talking to somebody that's not saying you don't talk to the client, they don't come up to you, but you don't go and, talk to them in public places, because it is what you're doing, your profession is letting people know that you have a relationship with that person. And unless the client said that was okay, we just don't do it. I've seen Facebook posts that say, my lawyer told me, that's a compromise of the privilege. So you want to counsel your clients and talk to them about putting anything that they've talked to you about in Facebook or whatever they're using, social media. You don't tell them never. You say for this amount of time until the case is over, right? Shelley, did you want to add anything to that?
I think social media is so hard for people to stay away from during hard times. It is just something that as advocates we have had to deal with many, many times on many different levels, but getting them to understand, even if they're being provoked, to not respond, and that's really hard. Don't let your friends respond for you. Don't use other people's accounts to respond. I mean, it can get so out of hand so quick. But just reminding them, of course, this is just a temporary time to stay off social media, to be mindful of where they may be breaching their own confidentiality and the consequences that come with, I think is so important whenever we're talking about waiving privileges and stuff and how that might impact her case. And so whenever we have stuff like that happen, we're always pulling victims back in and saying, hey, this is what we have seen or we have heard, and how this could impact her can help her think ahead, because they're so in the moment sometimes that they're not thinking about the consequences that might come afterwards. And just whenever we're disclosing information, being mindful that it's always best to have that client's permission in writing whenever possible, always up front, making sure that they know those informed consent pieces, and paying attention to our own policies and procedures whenever we're divulging information or whenever we might need to. And as an advocate, just making reasonable attempts to make sure that the victims know, hey, this is fixing to happen or this has happened, and take the necessary steps to protect her privacy and safety as much as possible at any given time.
I think cell phones have created a whole new dimension to lawyers for sure, trying to counsel their clients, because I can envision a scenario where a client texts her, even her sister or her best friend, and then they have an argument and the best friend shows it to someone else. It's out there. So just don't put anything in writing at all until we get the case concluded. And I see here a comment. I tell my client that it's an important time. We're promoting space from the abuser. So I do not supply the Wi-Fi password. Okay. Not, you might want to say a little bit more about that, but yeah, we're just gonna, it's so hard. This has become super challenging in the last 6, 7 years to do this. Another says, I tell them to text me the post before they post it on Facebook, because sometimes typing it out and sending helps fill the void of having it out there. So instead of being on Facebook, it was sent to me. But the client gets it. They're trying to get it out and they're reaching out to friends and family, but it's that toothpaste thing again. And once it's out there, we can't get it back. Uh, Wisconsin is a one-party consent state. I warn survivors, you cannot be sure someone isn't recording a conversation. That's great. Uh, you just have to be super careful and careful in counseling your client. Remember, it's their information. And if you counsel them and they put it out there anyway, then we have to deal with those consequences. But just making sure it's knowingly done, like Shelley said. We gave the warning, they decided they were going to do it anyway, and now here we are. And that happens in a lot of these cases, a lot. Okay, next slide. Now, any questions? Anybody want to say anything else about inadvertently waiving confidentiality, privilege, the different ways that can be done? Now we're going to move on to, so you have a privilege, so you have an ethical confidentiality duty. There are certain times that you must disclose by statute. And we're going to move into mandatory reporting. And Shelley, do you want to say a word before we even get started on the importance, because it goes for lawyers and their clients too, of this particular conversation has to happen at the beginning of the representation, the
Sure. I mean, for
mandatory report.
advocates, of course, we're always talking about safety, to advocate for her and not against her, to tell her upfront about mandatory reporting. And even if there are things that come up in her interview or during her story time or whatever, during the whole process of providing services to her, if anything comes up, having those conversations with her first. I know there have been many times throughout the years where we've had to debate and talk and discuss with the client what that might be, what that might look like, and if we were bordering on mandatory reporting, and saying, "Hey, I think we meet those steps and those requirements to be report to report." And honestly, as an advocate, I'm going to encourage her to report it herself. That way we're getting ahead of everything. I think if there have only been a few times where I've really been like, oh, we have to report this no matter what. Um, and the first step was to talk to the client about it, to disclose, hey, I think we have a possible mandatory reporting thing on our hands, and we're going to have to take action. This is what this means for you, just explaining everything out, and we would like to give you the opportunity to come forth before we do anything. And that has helped not only help keep that advocate client relationship intact, but help her understand we are there to help her. We're there to guide her, we're to advocate for her, and just making sure she feels that support, I think, is important as advocates. I think attorneys have a different perspective, but for us as advocates, making sure she knows she's supported in every step of the way is really important.
And this obviously, this duty to mandatory report child abuse and neglect is going to be different in every jurisdiction. If we can go to the next slide, it's going to be different in every jurisdiction, but it says something like a particular professional. I know in Oklahoma it's everybody. You don't have to be a professional. If you suspect child abuse and neglect, you're a mandatory reporter, and it comes with sanctions, usually misdemeanor, fines, things like that. Um, and know, letting that client know up front at that first meeting from the lawyer, I'm a mandatory reporter. If you disclose information to me that either is ongoing child abuse and neglect, or um, it's child abuse and neglect, it depends what the statute says. I am mandated by law to report it. And so we have a couple of hypotheticals coming up, and we're going to have you work through, because look, this seems easy. Child abuse, where the child is physically injured, bruising, broken bones that can't be explained, can't, not accidental, and child neglect, where you're exposing the child to domestic violence acts or things like that. I mean, this gets really murky and really, really difficult to know when the line has been crossed. Like Shelley said, in some cases it's easier, other cases it's not easier. And so the mandatory reporting piece we're going to talk a little more in depth about. The underlying issue here is you need protocols for that to help you, to guide you through it, especially if you work with more than one attorney in the firm, or advocates who may have 3 or 4 advocates in one office. What are the protocols? We don't just immediately report, we work through our protocols. And we really suggest those protocols be written, including when you're served with a subpoena. Do you this is mainly for the advocates. Do we turn that information over right away? No, you do not. We're going to follow protocol, which typically I would expect in many of the advocacy organizations there to report it to a supervisor. The supervisors are going to read it. They're, as a group, going to discuss it and how they're going to respond to it. And we're going to give you some tips for how to protect yourself from subpoenas in a few minutes. But don't do this in a vacuum. Even if you're one lawyer in a firm, you have colleagues, mentors that you can discuss. Okay, do you think they crossed the line? They haven't crossed the line, that sort of thing, because it gets murky real quickly. Let's go to the next slide.
I, I
Oh, go
also
ahead,
want
Shelley.
to add that we also need to ensure that we're being in compliance with the OVW provisions of confidentiality. Even though we're mandatory reporters, we also have that responsibility to notify the victims, and that's when, that communication line comes in to make sure they understand, hey, this is fixing to happen. And that we always, no matter what we're doing, that we're taking those necessary steps to keep safety at the forefront for her and protect her privacy as much as possible.
Yes. And think, everybody, for just a minute, think about what the repercussions are. I have a client. I feel like I have a duty to mandatory report. It's a small town. Uh, and I report the client to law enforcement. Oh, wow. Gets out in the community. Oh, don't go to her. She snitched on me. She did this. That's why it's so important at the beginning to let the client know unequivocally that you are a mandatory reporter. If this information comes to you, you're going to have to report. Just like Shelley said, advocates see this differently. But even attorneys, this is not a hard line. In some cases, maybe, but there'll be so many cases where it's not a hard line and you're struggling with it. There's a question, what was it called again? OVW, were you talking about the special conditions, Shelley?
The provisions of confidentiality. So OVW has the ha, and I can't remember what the exact title is, but it's talking about their confidentiality provisions and what they expect to happen. So how you're supposed to keep things confidential, where confidentiality talks about the data, and kind of goes through some of the things that we've mentioned, but it also has in there that if confidentiality is broken, let's say something has come up and confidentiality has been broken in by an advocate. Maybe she was having lunch, like the scenario said, and somebody actually heard her over talking about a client, accidentally just kind of got lost in the moment. Well, then you've broken confidentiality. OVW says you have the responsibility to report it in a certain time, that you have to notify the client, and that so there are different steps that you have to have, but it's all written out in those provisions.
Okay, Shelley, next slide I think is yours. And we're going to go through these hypotheticals here and just kind of do a knowledge check.
Okay, so our knowledge check for the moment is we are an advocate in a mandatory reporter jurisdiction. And we have a protective order for our client. And every Saturday night, the client invites the perpetrator over to her house. And he ends up beating the client in the presence of their 3-year-old child. What do you do?
Lawyers weigh in on this too.
Do you report her? Is it a mandatory reporter situation? Are we going to automatically call her in and say, okay? So for an advocate, I would say, I need to know a little bit more about some of the issues that are surrounding that. I need to know what is going on, why every Saturday night, what's happening. Does she have some safety things going on? What is going on? I need to make sure that we understand all the other pieces that are going to surround safety for her. I want to know what the statute says. I want to know exactly, as an advocate, what my requirements are for reporting and if this meets those requirements. I want to talk about those federal requirements as well. And I just want to even talk about the local pieces of that. So our state statutes and what everything, I want to consider everything before I make that call as an advocate. Our relationship with our clients is so important. If you're going to be reporting every client that comes to your program, then you're not going to have a whole lot of clients utilize your program once the word gets out. I think advocacy is so important for victims when they're coming through and making changes in their life, that advocates can make a world of difference. And once you pair them with attorneys, man, the amount of changes that a client goes through is impactful, and it helps them make such a huge change in their life that it's important to remember that relationship that you have with those clients is so important. And confidentiality is the cornerstone of all of that.
I just want to add the attorney's perspective. This was a spin-off of a case that I was working on. Um, and this, see where it isn't a bright line. Many of you are saying no. I saw someone who said no physical harm. Remember, it includes neglect. Is that neglectful, emotionally distressful, emotionally harmful to the child? That is a part of the general mandatory reporting statute. So in my instance, I brought the client in and counseled the client. This has to stop. Remember, I told you I was a mandatory reporter. I think on the other side, the advocate was safety planning, uh, trying to make sure that the victim and the child were safe. But I didn't make the report the first time, but I was nervous because it says every Saturday night. How long has this been going on? Is the child present? Uh,
Mhm.
Police came, ambulance came. How many times? And when we did a presentation to a multidisciplinary group, everybody had a different answer. Law enforcement had one, child welfare had one, advocates had one, attorneys had one. This is not to be taken lightly. And so I think the message, Shelley, and I want you to get, and if we go the next slide, we add a little bit to the hypothetical. It's not an easy thing to do. It's not an easy thing to do. So we're going to add this piece. The client reports this scenario to you each Monday. We don't know how many Mondays. Notes the ambulance and law enforcement were involved. And the client continues, despite your counseling, to say the batter is a good father, and she does not feel there should be any supervision on the visitation or anything like that. Does that make a difference to you? Child is present. Yes, yes. And
It
what if
makes a
she,
difference.
in some instances, she may take your advice.
Mhm.
Obviously, if there's a custody case, it's getting weaker and weaker, uh, and the line is so blurry. And what ended up happening in this case is after numerous counseling sessions, I tell her remember I told you, and I was telling her all along, I'm a mandatory reporter. And then I ask her, do you want to go make the report? I will go with you, but I will have to withdraw at that point and we'll try to get you another lawyer because that there's not going to be any trust there anymore, folks, when you make that report. And we had some sort of divine intervention to me here because the judge called us to court the day we were going to go report, and he did the report. It had already been done. And so, but it's so hard to do because, as Shelley said, it's going to get out in the community. We want to keep the child safe, yes, but you also want, once that trust is gone, it's gone with the client. So
So
just go
I
ahead,
think
Shelley.
this happened, I think probably years ago before there were any laws on the books that talked about in the presence of a child. And so this scenario is coming from a different time frame where now we have those on the books and we didn't have that before. But also I see some of the chat where the attorneys are saying I have to check out. In small communities, sometimes you're the only advocate. You can't, it's not an option for an advocate to say, okay, well, now I can no longer be your advocate. In sometimes you're the only one. And hopefully your program is growing and is bigger where you have an option to say, okay, I have to report you, but I'm going to hand you over to a different advocate who can help guide you the rest of the way. Because I think if they don't have that support and we're all going to walk away from her, she's never going to make those positive changes that she needs to in her life. And I'm thinking that from a different perspective as far as I know I'm an advocate, I'm not an attorney. I have the privilege to do different types of things in order to keep that relationship intact with her. But I also know in small tribal communities, it's hard to get an attorney to come in and help. We have the Circle Project, but trust me, it is hard for tribal programs to establish those legal assistant programs for civil legal in itself, and then you add domestic violence to it, and it's extremely hard to keep attorneys who are willing to take those cases because sometimes they're not the easiest cases to have. And you get things coming in and out of them, and perpetrators who are really bad perpetrators, they keep you in court for a really long time sometimes. So these scenarios of do I, should I, how, and they have, for me as an advocate, have more of an impact of how in the long run is this going to help or hurt her? What do I need to help her get through this process? And as an advocate, and always keeping in mind those safety issues that are coming, because now if she's reported, the child is in jeopardy of being taken out of her home. Where are they going to put him? Are they going to put him in the perpetrator's home? And now we have a child who is with the perpetrator who is in more danger now that he has nobody there to protect him. And so we're automatically thinking of those things of, okay, well, what's going to happen now as far as the child goes? Because sometimes with the victim being there, she is protecting that kid. And I know all those things about that is child neglect and that is everything. But in a real world situation, sometimes that child is not protected by the court. And as an advocate, I want to know what that court is doing in my neighborhood, in my town, in my tribal communities, so that I can make the bet, tell the client the best options for her and how to navigate through it whenever we get put in a situation that's not going to be best for that kid. And so sometimes it doesn't always look like it's going to be black and white. It's not black and white. Sometimes we make decisions and we pull out and we do different things because that is what we have to do in order to protect our license or whatever that might be. But then we're leaving a client in a situation that she's not going to have the best options for her. And so I just, as an advocate, I really have to look at all of these things before I walk away and say, nope, I have to report you and I'm done.
And
It's just not that easy.
I'll add the attorney's perspective to that. It depends on your mandatory reporting statute. So go read it. Because those of you who want to conflict out, you still have the mandatory reporting duty. If you conflict out, earlier, maybe you would be okay. But in Oklahoma, the mandatory reporting statute said everybody and no privilege, no duty defeats this responsibility to report. It was very aggressive, very clear. And if anything happens and there's an investigation, you just want to make sure that you've covered your bases there. So we're at the 30-minute mark, Shelley. We have 25. Let's go to the next slide. So maybe we can hurry through some of these because I really want to talk about the Circle Project. If you're served with a subpoena, advocate agencies, the lawyers probably already know how to get around this. That is a command to appear at a certain day and time to give testimony, or if it's a subpoena ducis tecum, I'm from Oklahoma, I'm sure that's not the appropriate Latin pronunciation. That's you must show up at a certain day and time and bring with you these documents. So that's the difference between those two kinds of subpoenas. It's not a court order in most jurisdictions. It's just a command. Sometimes the court clerk will send them out. Sometimes opposing counsel will send them out. Definitely sit up and take notice, but we're here to protect client information. And let's go to the next slide. I want to make the distinction here, though, from criminal cases and civil cases. In criminal cases, courts tend to hold to uh, the procedures of the statute, criminal procedures, because someone's safety is at jeopardy here in the criminal case. It's the defendant, and they're typically going to be more rigid in their interpretation of the subpoena if you're going to contest it. Let's go to the next slide. When we talk about civil cases, they're a little more relaxed, although it'll vary from jurisdiction to jurisdiction and judge to judge. They're generally more generous in letting you make your arguments on why or why not. This says less, that's actually a typo. More generous. So civil cases, you can typically fight these subpoenas, and the burden of the winning, what you need to tell the judge is sometimes more flexible. Next slide. We had, let's go back one, legal protection. Some of the things you can do if there is a subpoena, you can file a motion, lawyers, to limit the scope of discovery. They usually ask for the whole kitchen sink, so you can fight on that ground. If you lose and your motion for protection from discovery, you can also request that you be allowed to redact irrelevant, compromising safety issues that are requested in the subpoena. And also at trial, you can attempt to limit lines of questioning. So just putting those, the thing I did mostly was to file a motion for protection from discovery. We'd go argue in front of the judge. I'd argue safety. I'd argue any statute that promoted client safety, and then the redaction piece. Let's go to the next slide.
Knowledge
Shelley,
check.
yeah, 2
What
points we
is
need to
the
make.
what is the paramount focus? Safety. I think safety is always and should be the paramount focus of anything that we're talking about and doing, especially when we're talking about subpoenas or waiving the privilege of anything, and risking confidentiality. So safety is at the forefront. And always argue that the safety of your client is in jeopardy if the information is disclosed, because it is. We do not have the ability to know how a perpetrator is going to react. And one of the things that I learned early on as an advocate is sometimes the cases that have minimal abuse in them and those who turn to a homicide do not look any different. And so as an advocate, you are always making sure that that safety is at the forefront of everything, because we do not know when those cases will turn for the worst, and have had many clients themselves who may undermine, or not undermine, but might not think that safety is something that she needs to be thinking about all the time. So as an advocate, I'm always reminding her of the situation that she's in, and that she deserves to have a better life. And nobody needs to live in an abusive relationship like that. So always encouraging her.
I will add to that, Shelley. I had a case that the victim was murdered, and I was running a clinical program at the time. And I remember, first of all, the trauma of hearing it, and then going and pulling the files and just spending the whole day looking for something that was different than other cases. Yes, he wrote her letters of his love. Yes, he had been making threats in these letters. And Shelley, I couldn't see anything that would have been, oh, I'm going to tell my students, always be watching for this. It's every case has the potential to end up in a homicide. And I think some clients think they can manage the anger and they can manage the danger and they'll know when it's time to get out. And unfortunately, that's not always the case. Okay,
Yes,
let's
that's
go to
what we
the,
learned early on. It is
yes.
not always easy to know what will happen. And I think that's why safety is so important whenever we're dealing with domestic violence cases at any point throughout the process.
Next slide. We're rushing through these because I want you all to hear about the Circle Project and how they're pairing these lawyers and advocates and they're working in sync. So, Shelley, you want to take this one?
Um, do your states protect confidential info statutes protect confidential information? If not, be careful what you write down, have a written protocol, and keep minimal information in client files. So I want to kind of talk about, we've talked a lot about privilege as far as attorneys go, and um, sometimes in our tribal courts or even in some of our states, advocates also have privilege. And there are different requirements that advocates might do. Maybe they do a 40-hour process or training, whatever that might look like, but they also get that privilege of having their files protected, but not everywhere. And so sometimes advocates need to be proactive in making sure that the information that they're keeping, the notes, whatever that might be, that there is a written protocol on how they're keeping those notes, that you're keeping in mind that somebody may come and try to get your records. Somebody's always asking information. I think it's important to remember that as programs, as advocates, our basic rule is we do not share that information no matter what, and that there are steps that we're going to do to try to protect it no matter who is asking. And I think that gets really tricky, especially when tribal programs and your tribal administration or your tribal leadership is coming in and saying, my niece, my nephew, my daughter, my aunt, my mother is coming in through your program, and I want to know if they came, first of all, and made contact with you. I want to know what services you're providing to them. I want to make sure that they're getting the best possible. And at any point, you cannot divulge any of that information. And so always taking that opportunity to, in tribal communities and tribal programs, to educate your leaders about confidentiality and why it's so important, I think is the best possible to get ahead of that, but also to make sure that you are being mindful of what you're writing down in all of your files, and that we're not keeping notes or anything that could harm her or hurt her, as far as um our own opinions, but that we are keeping track of things that we need to, like the data that we need to for reporting, the services that we may have done, like transportation and providing different things like that. I think is thing keeping our information in our clients' files to those things that we actually need and are going to use for grant purposes and for actually building on those, so that maybe if we're not providing a certain service, that we can come back and say we had 10 clients who actually needed transportation and we don't provide that, so now maybe we do. So making sure that our programs are growing in a way that our clients are telling us these are the resources that we need. So just information like that, but not any information that can be used if it gets out to harm her in any capacity. One of the things that I remember is just having stories told to me about advocates' files being taken and in court and read openly about the notes that they were writing down. And that would just be devastating to me as an advocate if I had to let a file go. And I think the most important thing as an advocate is to remember is to never give up information. Never, 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 never. That you're always going to have process and protocols in there to help protect, keep that from them. And our OVW provisions also say that we must help protect that information. And more importantly, that we have to write down the steps that we took in order to protect that information. And that's how important that is, to make sure that we are always trying to keep things at a minimal and confidential.
Thanks, Shelley. And I'll just point out lawyers have a couple of privileges that are too pretty hefty here. Attorney-client, unless it's inadvertently waived, it's privilege, and attorney work product. So, but I want to encourage everyone in every tribal jurisdiction they're working in to check to see if those advocates' records are confidential. If not, they're vulnerable to a subpoena. So everything Shelley just says becomes vitally important then at that point. Next slide. Okay, Shelley, here we are to the Circle Point project, and we have 11 minutes. How do you want to tell us about the Circle project first?
I do, but I really think if we can, and I'm so sorry, but there is a statement in the chat that says, "What do you do if your tribal leadership comes and says they demand to know the identity of who is receiving financial services, how we educate them on the VAWA confidentiality federal requirements, but they demand that at least one of their leaders or someone they approve are privy to personally identifying information. What do we do when they will not take no for an answer? We've seen programs get tribal leaders approved um, through their grant managers to share. That's interesting. Personally identifying information in staff client cases with them. It is still seen a violation of privacy for clients leading those who truly are victim services from getting assistance from their local tribal programs due to lack of trust. It leads to low morale within the program, and there are 3 tribal programs in our service area where all of them have these issues plaguing their programs and staff. And I feel for you. That is such a hard place to be in. I have had over I worked at a tribe for maybe over 22 years in the domestic violence program. And believe me, keeping um, confidentiality at the forefront was so extremely hard. The way we did it was always trying to make sure that leadership had access to coming to all of the training sessions that we had, invited them to our training, invited them to OVW trainings, bringing in personnel people and just educating them on the whys. That safety piece was so important. But also knowing that, sometimes it doesn't matter. You can be the best advocate possible, and if you won't give them the information they need, they can get rid of you. So sometimes it becomes really hard to keep those confidentiality pieces together. One of the things that I would bring up, if none of those actually helped, was also to make sure that they understood that the OVW provisions say that if we don't keep those things confidential and keep those things private, that we are in jeopardy of losing our funding as well. So it could jeopardize the whole program. Um, and just being creative in the way that we are always educating them, I think is helpful, and trying to always have at least one leadership who understands that, and if not, forming a elder group in your community that says, hey, this is why this is important, and educating them so that you have that protection and help and that voice for your program when you need it.
I found,
um
go ahead, sorry.
Go ahead. I'm sorry, go ahead.
I was just going to say legally, the legal perspective is we've gotten this federal funding, and if we violate these special conditions, we will lose all of the federal funding and potentially other sanctions. So that has been useful. And then from outside, let's say state subpoenas into Indian country, we have been able to get tribal attorneys, if the tribe is the grantee, to say these are tribal records. And that totally dissuades them, because if you're trying to get at their tribal records, then that's a sovereignty issue and it's going into tribal court and there will be protracted litigation. So just a couple of ideas. Um, yeah, Shelley's right. Sometimes less is more in the records. I remember there being numbers instead of names. I remember files weren't kept in a location for very long before they were moved out into a secure location elsewhere off of premises if someone wanted to come in after hours and go through the files. They're just a whole host of steps, but not absolute.
I will tell you it wasn't easy making sure that we kept that. But the longer we took the stance and we're not sharing that information, we're not sharing that information, we're not sharing that information, the more it got out in the community, the more the victims trusted us, the more we were established, the longer we were established, leadership came in and out and understood that our program meant that we were keeping things confidential. So as time went on, we just developed that, and it was never easy. Being standing before your leadership or those who you might be related to or those who are pushing really hard at trying to get information, my stance was always no. And I did a lot and lots of praying during those times because I never knew what was going to happen. But I will tell you, I would have lost my job before I gave up anything. I mean, that's just the way it was going to be. And so after that was established in our community, it was a lot easier. So now I will try to. That's such a hard issue that it just really gets me going. So I apologize, but I'm going to go into the Circle Project now. We are Native Alliance Against Violence. We are a tribal coalition here in Oklahoma. We've been established since 2009. And I am currently the executive director of the coalition. We are the only domestic violence and sexual assault coalition in Oklahoma right now. We don't even have a state coalition, so hopefully that will get fixed soon. But we provide a lot of technical assistance and stuff to the tribal programs here who have domestic violence and sexual assault programs. In this, we have developed the Circle Project, and it serves and helps serve all of those clients and victims who are coming through domestic violence and sexual assault programs. So currently, we have roughly 32 to 34 programs who have domestic violence and sexual assault programs throughout Oklahoma. It is awesome. Whenever we first started this, we did not have that many programs who were providing services. A lot of times those programs are trying to add additional services and or trying to apply for funding. And even if they get legal assistance funding, it is not always the easiest to find attorneys who will come work for you. And or stay within the program or even understand the dynamics of domestic violence in order to have those going. So the Circle Project supports and collaborates with all of those domestic violence and sexual assault programs who want to utilize the program. Some of the programs have legal assistance, and if their money runs out before time, or they have a case that is more extensive than what their current attorney, maybe they've got a brand new attorney or something that can provide those services, then we can always step in and help them. And so sometimes we get referrals for those cases who are extensive and might have more dynamics of DV in them. And sometimes we have programs who just don't have the ability to have their own legal assistance. And so they're referring programs or clients to us throughout. We provide services to domestic violence, dating violence, sexual assaults, and stalking victims. And I think that's pretty much the kind of what we're looking for whenever we're providing services. So go ahead and do the next slide.
And these are tribal programs, right, Shelley? It
Tribal
has to be a
programs.
tribal victim advocate program.
Yes, we are working with all of our domestic violence sexual assault tribal programs. With our attorneys, we're asking them to provide that civil legal service. We have victims' rights legal advocacy. They work collaboratively and agree to work with all of the tribal victim advocates out in the communities. And so whenever an advocate identifies the need for legal assistance and they do not have it in their service, they can contact us, submit an application, and say, hey, I have recognized the dynamics of either domestic violence or sexual assault in here. They are a victim, they need legal assistance, and then we are going to collaborate with them to provide an attorney to them. We normally have about 5, I think right now we have 4 attorneys working with us, and they go everywhere in Oklahoma. They can provide in tribal courts, state courts, and federal courts if necessary. The role of the attorney is to just keep them advocates informed and the clients informed of the cases and just kind of work in tandem with the advocate as much as possible. Next slide. The role of the victim advocate, most of the time, if they are going to be referring to our project, we want to meet with them, make sure that they're providing those advocacy services, that they're doing the safety plan, that they're doing the transportation, that they are setting up appointments for the attorney and clients to meet together, sometimes even providing the space for them to meet if necessary, because our attorneys travel to their communities. So we're not bringing people in. Our attorneys are going to those tribal communities out in Oklahoma. We're asking the advocates to be that middle point of contact to try to help with that and attend court with those clients to keep that attorney updated. Because sometimes clients will tell the advocate about maybe a protective order being what is the word, were
Dismissed?
violated. Yeah,
Oh, pilot.
and so they'll come in and tell the advocate what has happened over the weekend. So making sure that that advocate is keeping the attorney informed and help gather information and file stuff as necessary sometimes. And we add that in there because a lot of times our attorneys are so far away that if they have to travel an hour to a tribal community to just file something for 5 minutes and go back, that is a waste of our grant funding, and we try to keep it to a minimum. So we're asking advocates to just walk that paper over to their courthouse, and sometimes that works out better. Um, Next slide. What types of legal representation is available? We do civil legal assistance, whether that's divorce, custody, child support, whatever is stemming from that domestic violence situation that victim has been in. Sometimes we do landlord-tenant issues, different things like that. So it just is going to be kind of what is happening in that situation. And we do state and tribal courts the majority of the time, but they can go into federal courts as well. Next slide. The eligibility requirements, we are relying on the program advocates to make that finding of domestic violence or sexual assault or any of those to make sure that they are doing that. The eligibility requirements are coming from those programs, and the programs are the ones who are in contact with that client, who are interviewing that client, who are saying, yes, you meet the qualifications for our DV program or our sexual assault program. So therefore, then they're going to actually, they have been established, and so the victim advocate in that tribal community is making a referral to us, and all we're doing is just connecting them with those attorneys out there in the field. Oklahoma tribal advocates, they have to, if they have a referral in the process, they are doing our intake sheet and they're emailing it to us. And then we are working with our attorneys to see who's closest to that area and who has the ability to actually go to that tribal court or to that tribal area out in the community. So it's a lot of coordinating. We have we have a lot of programs out there who utilize us, and roughly or usually have about 115 cases going out all at one time. Next slide. How
Okay,
long have they been
Shelley,
in existence?
we
Yes.
only have maybe 1 minute, maybe two, because we want to give Marlon time to do the resources and highlight the website. And
Okay.
inviting everybody, if you could stay 5 minutes over, Marlon's going to be doing a walkthrough on the website. But I'm going to ask Shelley one question, and my favorite question of all of these is what challenges have you encountered with attorneys and advocates working together?
It is not always, yeah, we don't always see the same. We have quite a few challenges. Sometimes we need way more than 3 minutes to go over a lot of those challenges, but I will tell you quickly that sometimes it's communication issues. Sometimes it is about that confidentiality privilege piece that is going on. Sometimes it is about maybe, gosh, we've had quite a few challenges, but the way that we've addressed them is that we come in and we talk about it with the advocate, we talk about it with the attorney, and then we bring it into a mentoring a mentoring meeting where we're talking about those issues and coming up with some solutions with all pieces involved. It has not been the easiest sometimes, but we do work through some of those challenges as a group. And that's kind of what we're asking for. Having an attorney and an advocate work on those legal cases with domestic violence victims and sexual assault victims brings the best outcome that I have ever seen. And it's why I advocate for legal assistance in our tribal communities so much. It makes the biggest changes in their life. If they can walk away with the things that they need and their children, it changes their life tremendously. And so just setting up this project and making sure that all victims have the ability to access some type of legal assistance has been awesome. And I encourage everybody to try to reach out and develop some of those pieces so that victims have the ability to go to court and actually get custody of their kids.
Thank you, Shelley, so much for all that. I know we may have some questions that weren't answered, so we'll try to get to those in the very near future. Suzanne's getting those gathered up and copied for us. And then Marlon, I'll turn it over to you.
Thank you to our presenters and thank you to our staff support, Suzanne Garcia. On the screen, we have our two presenter emails. Please feel free if you think of anything post this recording to email our presenters. Quickly, we have a tribal legal resource code. This resource is available on our main organizational website, www.home.tlpi.org. This one here is Victims' Rights Code, a condensed guide for drafting tribal victims' rights codes. Next step, also available on home.tlpi.org, our pocket guide for tribal victim advocacy in criminal cases. And this is the resource page. Once you access our main website, there is a publication subpage that we have it listed out by subject and or by series. This is our team contact information. If you have any questions, please, again, we welcome you to visit our project website, triballegalservices.org. And our group email is TLAPS, TLAPS at tlpi.org. And please feel free to fill out your survey session webinar evaluation here, access either through the QR code and through our link. We appreciate your attendance. And I'm going to go ahead and end the recording now. And those who are able to stay over will do a website preview. Again, thank you to Shelley Miller from the NAV and also to Judge Kelly Stoner and for our project support, Suzanne Garcia. We'll leave the screen on. Thank you everybody for attending today's session.